Hi, I'm Gregory Germain, the Frugal Law Professor. In this video, I will discuss the legal issues that Donald Trump faces in seeking to overturn the nearly $500 million judgment that Attorney General Letitia James obtained against him for overstating his wealth. I will review the factual history of the case, Judge Engeron's ruling, and evaluate Trump's chances of overturning Judge Engeron's factual findings and legal conclusions. The background of the judgment. Let's first look at the background of the case and the court's holding. Over many years, Donald Trump prepared personal financial statements claiming to have a net worth of more than $4 billion. He submitted and showed those financial statements to sophisticated lenders like Deutsche Bank and to insurance companies when he applied for loans or policy. The insurance companies and lenders who were given the statements did not complain to or seek the assistance of the Attorney General. They also have not filed their own fraud claims against Trump and have not claimed to have been harmed in any way by Trump's financial statements. It is therefore difficult to ignore the political nature of these charges. During her campaign for election, Attorney General Letitia James made it clear that Donald Trump would be a prime target for investigation if she was elected as Attorney General. She called the then president a con man, a carnival barker, and pledged to shine a, quote, bright light into every dark corner of his real estate dealings. True to her promises, James brought this case charging Trump with fraud for greatly overstating the value of the properties in the personal financial statements he submitted to lenders and insurance companies. What is fraud? In order to understand the legal issues in this case, it is important to understand exactly what fraud is, because fraud has specific legal elements and is normally a very difficult claim to prove and win. New York law requires a plaintiff to prove the following 6 elements of a claim for fraud. Number 1, false statements of fact, not opinions. The general rule is that fraud must involve false statements of fact, not false statements of opinion. There is a limited exception for false statements of opinion made by someone who is an expert to someone who is a novice. But Trump is not an independent expert concerning the value of his own properties, has an obvious conflict of interest in valuing his own properties, and his lenders and insurance companies were not novices. It is doubtful that Trump's false valuations would rise to the level of fraudulent factual misrepresentations. While Trump's valuation conclusions were mostly opinions, there were false statements of fact underlying those opinions, the most serious of which was greatly overstating the square footage of his apartment in Trump Tower, which he claimed was an error, not an attempt to defraud. The actual factual value of Trump's properties would require an arm's length sale in the marketplace. Sophisticated, professional, real property appraisers often disagree significantly regarding their estimates of the value of real property. Trump's current value financial statements are also very different from traditional accrual method financial statements, which are based on verifiable historical costs and adjustments allowed by generally accepted accounting principles. The lenders here were interested in Trump's estimate of his current net worth, not the book value of his properties under traditional historical cost accounting measures. Verifiable historical cost numbers are facts. Opinions of current market value are not. Non-disclosure fraud. Omissions to state a fact can also be fraudulent when there is a duty to speak. A party has a duty to speak if he has a special fiduciary relationship with the victim, if there is a statutory or common law duty of disclosure, or if the person elects to speak but does not speak the whole truth. Donald Trump elected to speak by showing his net worth statement to lenders and insurance companies. There is a legitimate question about whether he had a duty to disclose more than he did. But then again, the lenders and insurance companies could have asked him for additional information concerning the basis for his valuations. The requirement for additional disclosure was not the focus of the court's inquiry. Second, Scienter. A fraud victim must show that the perpetrator intended to deceive. That requires the victim to show that the perpetrator either knew that the statements were false or was aware that the statements might be false. The intent must be to mislead. If the perpetrator believed the statements were true, the fraud claim fails. 3. Materiality. The standard formulation of materiality is that the misstatement or omission, quote, has a natural tendency to influence or was capable of influencing the decision of the defrauded party. If the statements had shown his net worth to be, say, the $2.6 million that Forbes magazine estimated him to be worth, as opposed to the 4 or more billion that Trump claimed, would it have made a difference to the lenders or insurance companies? If they would have made the loans or issued the insurance policies with the lower valuations, the misstatements might not have been material to the transactions. 4. Reliance on the truth of the statement. The victims must believe that the statements are true and reasonably rely on the statements to their detriment. This is often the most difficult element to meet, and it would be difficult here. The Attorney General's main witness on Reliance was a retired Deutsche Bank executive who testified that he thought Trump's valuations were overstated, but did not know how overstated they were. If the witness did not believe that the statements were true, then he could not reasonably rely on the statements. A recipient on notice that the statement might not be true has a duty to inquire and investigate. Sophisticated lenders cannot close their eyes to obvious conflicts of interest and red flags when a borrower values their own property. That's why lenders normally require an independent third-party valuation when the valuation is important to them, as they did regarding the collateral for their secured loans. At best, the evidence showed that the lenders considered Trump to be a wealthy guy whose personal guarantee for the secured loans that they made would make repayment of their secured loans more likely. And that was true. He is a wealthy guy whose personal guarantee had value. The testimony did not show that they reasonably relied on the specific valuations listed in his net worth statement. 5. Causation and damages. Causation is the requirement that the misrepresentation be an actual and proximate cause of the victim's loss. This means that there must be a sufficient connection between the fraudulent statements and the loss incurred by the victim. The loss must have been the result of the false statement and not the result of other factors. The Supreme Court in securities cases has added an additional loss causation requirement, that the victims show that they actually suffered a loss and not simply made a lower profit than they would have made if the statement had been true. There was no showing that Trump's misstatements caused the recipient any loss, or even that the insurance companies or lenders actually incurred any losses in connection with their dealings with Trump. In my opinion, the evidence at trial would not have been sufficient to allow Deutsche Bank or the insurance companies, if they in fact had suffered a loss and brought a fraud claim, to recover damages, because many of the elements for a fraud claim were not established. Executive Law Section 6312 and the Attorney General's Superpowers. Judge Engeron ruled that the normal rules for fraud are not applicable in an action by the Attorney General under Executive Law Section 6312, which gives the New York Attorney General broad powers to prevent anyone in New York from committing fraud. Section 6312 is normally used by the Attorney General to protect unsophisticated consumers or investors, people who are likely unable to protect themselves from being defrauded. This case is novel in using the section to charge Trump with defrauding sophisticated lenders and insurance companies who were not complaining to the Attorney General, have the ability to protect themselves, and have apparently suffered no harm. Under existing case law, because of the broad anti-fraud purpose of Section 6312, the Attorney General is not subject to the usual elements of fraud when seeking to stop people from using false statements to mislead the public. If a scammer is making false representations to sell products or raise money from the public, the Attorney General can stop the conduct without showing that the potential victims have already suffered harm. But stopping future harm is very different from punishing past transgressions. The statute also gives the Attorney General the power to recover damages or disgorgement for unjust enrichment of ill-gotten gains on behalf of the victims. But that power is there to protect victims and prevent perpetrators from profiting at the victim's expense. The fundamental question is whether the Attorney General can recover either damages or disgorgement for past conduct without showing the standard elements of fraud. Does this rather obscure anti-fraud provision give the Attorney General the superpower to recover hundreds of millions of dollars in disgorgement from a political opponent who used an overstated financial statement that was not relied on as true by sophisticated lenders and insurance companies he dealt with when they suffered no actual loss or harm? Judge Engeron's judgment. Judge Engeron made very detailed findings of fact with specific citations to the trial record showing that Trump's valuations were inflated. Trump's numbers were based on seriously flawed and incorrect appraisal theories and data. Trump and his employees ignored actual appraisal data that they had, misquoted appraisers, and used unrestricted values when the properties were subject to legal restrictions. The picture painted by the evidence is that Trump instructed his minions to justify high valuations for his properties. His minions came up with flawed theories and justifications for the numbers Trump wanted. In his carefully drafted 92-page opinion, Judge Engeron carefully documented his factual findings with specific references to the trial record. There was very strong evidence that the values in Trump's financial statement were overstated and were not based on careful, proper methodology and legitimate sources. After making those careful findings of fact showing that Trump's financial statement was overstated, Judge Engeron concluded that Trump and his companies have been engaged in a pervasively fraudulent enterprise. To remedy that pervasively fraudulent enterprise, Trump, his family, and his executives were barred from serving as officers and directors of any entity in New York for at least 3 years, and some employees were barred for life. A retired judge was appointed at Trump's expense to oversee and monitor the Trump Organization's financial activities in the future, and Trump must hire a new director of compliance appointed by the court to establish procedures and controls to prevent inaccurate financial reporting in the future. Trump and certain of his entities were also ordered to pay nearly $500 million in unjust enrichment to the Attorney General. By my calculations, as of March 24th, 2024, Trump would owe the Attorney General about $458 million under the judgment, with 9% post-judgment interest accruing at the rate of around $113,000 per day. So what are Trump's prospects on appeal? Trump intends to challenge both Judge Engeron's factual findings that his financial statements were false or fraudulent, and Judge Engeron's legal conclusions that led to the judgment for nearly $500 million of unjust enrichment. In evaluating Trump's chances on appeal, it is important to understand the different legal standards for challenging findings of fact and conclusions of law. Factual findings must be clearly erroneous. In order to overturn Engeron's factual findings on appeal, Trump will have to show that the findings were clearly erroneous, which means that there was no basis in the trial record to support the judge's factual findings. Judge Engeron did a very careful job of citing to the record to support his factual findings. Given the extremely high standard of review, I don't think Trump has much of a chance of overturning Judge Engeron's factual findings. Judge Engeron's determination that Trump greatly overstated his net worth will be affirmed on appeal and was likely correct. De novo review of legal conclusions. Trump's appeal regarding Judge Judge Engeron's legal conclusions is much more promising. Legal determinations are reviewed on appeal de novo, which means that the appellate court may not give any deference at all to the trial court's legal conclusions. As discussed earlier, Trump's most promising challenge is to Judge Engeron's legal conclusion that the Attorney General does not need to establish all of the normal elements of a fraud claim in order to recover damages or disgorgement. The Attorney General in the state of New York were not harmed in any way by Trump's overstated financial statement. Any recovery by them will be a complete windfall. While Executive Law Section 6312 does give the Attorney General the authority to protect the public from fraudulent activity and to recover damages and disgorgement on behalf of victims, but it was not designed to punish misrepresentations that did not cause harm to actual victims. Determining the proper scope of Section 6312 is a prime target for Trump's appeal. Trump has a strong argument that Section 6312 does not give the Attorney General broader power to recover damages or disgorgement for unjust enrichment than an actual victim would have. In my opinion, Judge Engeron went too far in holding that the Attorney General has the power to punish lies that were not relied on and did not harm anyone. And the appellate court should recognize the scary political implications of giving an Attorney General that kind of power. It's one thing for the Attorney General to use her authority to protect innocent, powerless members of the public from being deceived. It is quite another to allow the Attorney General to target and punish a political opponent who obtained loans and insurance policies from sophisticated lenders who are well able to protect themselves and perform their own investigations and who were not harmed by the statements. Would this limit on the Attorney General's powers overturn Judge Engeron's entire judgment? I don't think so. The court might well allow the enforcement of Judge Engeron's administrative determinations, such as appointment of a monitor and compliance officer, as necessary to prevent Trump and his organization from making excessive claims in the future. But it would not sustain the nearly $500 million disgorgement award for unjust enrichment. To uphold the Attorney General's superpowers to punish political opponents by uncovering false statements that damage no one is just too extreme and would invite similar political retribution in other jurisdictions. The calculation of Trump's unjust enrichment. Engeron's second questionable legal ruling is his calculation of the amount of disgorgement for unjust enrichment. Normally, to recover disgorgement, the plaintiff must show that the defendant was unjustly enriched solely as a result of the unlawful conduct. One of the classic English disgorgement cases is Redding versus Regum from 1948, which is taught today in most corporate law classes. In that case, the court allowed the government to recover bribes that were paid to a military officer who, while wearing his military uniform, escorted a truck containing contraband past checkpoints in Cairo during the Second World War. The court held that the bribes were solely for the use of the government's military uniform to get past the checkpoints and so had to be disgorged to the government. The court made it a point to distinguish cases where the gain was not solely attributed to the wrongful conduct. The court gave an example of an employee who, in breach of his duty to the employer, left his post to engage in gambling. The employee would not have to disgorge his gambling winnings because the breach of duty to the employer was not the sole cause of the gambling winnings. The winnings were also the result of the employee's luck and skill. Thus was established the rule that disgorgement of profits must be directly attributable to the wrongdoing and not to other factors. Judge Engeron ruled, for example, that Trump had to disgorge all of the profits he earned from the development and sale of the old post office project because he borrowed funds for the development using his financial statement. Judge Engeron's theory was that Trump would not have received the loan to redevelop the property if he hadn't used his overstated financial statement, and therefore all of the profits earned in the development and resale had to be disgorged. But those profits were not attributable solely to the use of the inflated financial statement. Maybe he would have gotten the loan at a higher interest rate, or from another lender, or even from the same lender on the same terms if the financial statement had been accurate. The profits earned on the sale were also due to many other factors, including the redevelopment work, rising real property values, and many other factors. Engeron essentially used the fruit of the poisonous tree theory to require disgorgement of all profits from the transaction, even though those profits were not directly attributable solely or probably even primarily to the overstated financial statement. So even if the Appellate Division accepted Judge Engeron's conclusion that the Attorney General has superpowers to recover disgorgement of gains without showing that a victim reasonably relied on or was harmed by the overvaluations, Judge Engeron's award greatly exceeds the actual benefit that the Trump organization received directly and exclusively from the use of the excessive valuations. Obtaining a stay pending appeal. On Monday, the Appellate Division extended the stay on enforcement of the Attorney General's judgment for 1 week to allow Trump to post a $175 million undertaking rather than the nearly $500 million undertaking that would have been required by the judgment. $175 million is still a heck of a lot of money. What does Trump have to do to obtain that undertaking? Under New York law, specifically CPLR 2501, an undertaking can be posted in cash or in, quote, unregistered bonds of the United States or the state, unquote. Posting cash is a poor option because it means that you do not earn any interest on your money during the appeal. I don't know if unregistered bonds are still available from the United States or the state of New York these days, as most bonds today are registered in the name of a party. So that option might be difficult too. Alternatively, CPLR 2501 allows the posting of an undertaking by an insurance company or by an individual who agrees to serve as a surety. Most judgment debtors obtain a bond from an insurance company to obtain a stay pending appeal. Trump obtained a $91.6 million bond from the Chubb Insurance Company in the E. Jean Carroll defamation judgment. But insurance company bonds are expensive. The insurance company will require an ironclad indemnity agreement from the judgment debtor to reimburse the insurance company if the insurance company has to pay the bond, which it will have to do if the judgment debtor loses the appeal. For a judgment of this size and for a private individual, an insurance company will almost certainly require collateral to secure the indemnity obligation. And of course, the insurance company will require the payment of a hefty fee for their trouble. Getting a bond from an insurance company would be the cleanest way to meet the requirement, but a bond of that size is going to be expensive. The undertaking statute also allows an individual to serve as a surety. Under CPLR 2503, an individual surety for over $1,000 must own real property in New York, having equity exceeding the amount of the judgment, and will have a judicial lien imposed on that real property to secure the amount of the undertaking. The individual who acts as a surety must claim that the value of the real property above liens and encumbrances exceeds the undertaking amount. The Attorney General can dispute the value of the surety's real property in a justification proceeding under CPLR 2507. So one way to avoid the high cost of obtaining a bond from an insurance company would be for an individual owning valuable real property in New York to act as a surety. This could be a friend or financial supporter of Trump's, or it conceivably could even be Trump's Trump himself acting as his own surety. An undertaking would leave the surety in control of their property, even though there would be a judicial lien on the real property that would prevent the surety from selling it or borrowing against the property without satisfying the lien. The statute raises some questions about the surety process. For example, the statute requires the surety to be the sole owner of the real property. Trump, for example, may not be the direct owner of any of his real properties if the properties are held in separate legal entities, as is usual today. Is Trump the sole owner of a property if he owns 100% of the LLC interests of the entity that owns the property? It's an interesting question involving a statutory provision that is rarely used. Also, should Trump attempt to serve as his own surety, the Attorney General could dispute Trump's valuation of his property in a sufficiency hearing. That would be a good show for the public and rather ironic after the trial in the underlying case involving Trump's valuation of his properties. So it remains to be seen whether Trump will pay for a bond issued by an insurance company, which I think is likely, or whether he will attempt to comply with the requirement for an individual surety. Conclusion: Trump has 1 week to post a $175 million undertaking to obtain a stay of enforcement during the appeal. It remains to be seen whether he will obtain an undertaking from an insurance company or whether he will attempt to obtain an individual surety bond by granting a judicial lien on real property of sufficient value, which might be cheaper than an insurance company bond. Once the bond is posted, the focus will shift to the merits of Trump's appeal. The appeal will likely be a long process, taking more than a year, unless the Appellate Division decides to expedite the process. On the merits, I do not believe that Trump will be successful in challenging Judge Engeron's factual findings that his valuations were excessive. Judge Engeron's factual findings were carefully supported by references to the record, which is all that the clearly erroneous standard of review requires. Trump's focus on justifying his valuations will detract from his stronger challenge to Judge Engeron's legal conclusions. I believe Judge Engeron was wrong in holding that the Attorney General has superpowers to recover damages or disgorgement without meeting the normal requirements for a fraud claim, including a showing that an actual victim relied on and was harmed by the misrepresentations. Giving the Attorney General that kind of superpower to target a political opponent for false statements that were not relied on and did not harm anyone undermines basic principles of fairness and the rule of law. There is nothing in Executive Order 6312 that requires a result like that. The Appellate Division can easily and sensibly distinguish between actions by the Attorney General to prevent future harm, in which reliance and damages need not be shown, and actions by the Attorney General to punish for past harms, in which all of the elements of fraud, including reliance and damages, have to be proven. That ruling would allow the ministerial parts of Judge Engeron's decision, such as requiring a monitor or compliance officer to stand, without the monetary recoveries that are so doubtful. This is my preliminary opinion and analysis of the case based on my evaluation from available public sources of information that I have reviewed. I did not sit through the entire trial and do not have access to all of the documents and information that were produced in the trial. There will be future briefing of the issues by the parties, and there may be many issues raised that I have not considered. This discussion does not represent legal advice to anyone. I am sharing my thoughts about the case as part of the public dialogue. I welcome you to post your respective and thoughtful comments and disagreements below to advance the public discussion of these interesting legal issues. Goodbye.